Good morning, everyone. Thanks for joining us for our year-end webinar, Speed Dating for Legal Compliance, What You Need to Know to Start Off 2023 Off Right. My name is David Shapiro. I'm chair of Saul Ewing's Tax and Employee Benefits Practice, and I'll be your moderator for today's program. Before we begin, I have a few housekeeping notes to review before we move into the introductions. First, on questions. If you have any questions about anything we cover, you can submit them to our presenters via the chat feature at the bottom of your screen. We'll do our best to answer all the questions within the time we have allotted, but if we don't get to your question, we can reach out following the webinar. In addition, we'll conclude the webinar with an opportunity to join a breakout room for smaller group discussions and specific questions. Each room will be geared toward a specific legal specialty area and led by one of today's presenters. Today's program has been approved for CLE credit in New Jersey, which is accepted in New York and Pennsylvania, and we have applications pending in Delaware, Florida, Illinois, Minnesota, and Virginia. In order to verify your participation and receive your certificate of attendance, you'll need to complete a brief continuing education verification survey and note the 2 random numeric codes that we will provide during the webinar. The verification survey link was included in your reminder email of this morning and is also in the chat feature. Please be sure to complete the survey within the next 5 days. We'll follow up today's program with a thank you email that will include access to the presentation materials, continuing education verification survey, and any other relevant materials we'd like you to have. Now, since we are in a Zoom meeting format, we ask that you remain on mute during the presentation and then come off mute when you go into the breakout rooms. And of course, this is a legal presentation, so we have a legal disclaimer. The provision and receipt of the information in this presentation is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who've been informed of the specific facts. Now, before we begin the first presentation, I want to briefly introduce today's panelists and topics. First up will be Alexander, or Sandy Bylas. Sandy is the co-chair of our firm's cybersecurity and privacy practice, resident in our Philadelphia office. Sandy will discuss privacy and cybersecurity compliance and litigation trends. After Sandy comes Ruth Rawls. Ruth is vice chair of the firm's litigation department and also is a member of our labor and employment practice residing in our Princeton office. Ruth will discuss employment issues. Next up, we will have Nikhil Mehta. Nikhil is an associate in the firm's corporate practice who resides in our Chicago office. Nikhil will discuss corporate housekeeping and how to avoid some common mistakes. After Nikhil will come Andy Daly, vice chair of the tax and employee benefits practice, resident in our Minnesota office. Andy will discuss employee benefits and executive compensation issues. Then I will talk about some tax considerations for the coming year. And finally, Mark Simpson, who's co-chair of the firm's intellectual property practice, resident in Philadelphia, will cover IP audits and tidying up your IP portfolio. Now, after these presentations, we're going to have breakout rooms for smaller group discussions. Each room will be geared toward a specific topic, and participants can choose whichever room they'd like to join. So now I would like to introduce Sandy Bylas to talk about privacy and cybersecurity compliance and litigation trends.
Thanks, David. Hi, everybody. Thanks for joining us. As David said, I'm Sandy Bylas. I'm in our Philadelphia office normally, although right now I'm at home, and I am the co-chair of our cybersecurity and privacy practice. I want to talk about some privacy and cybersecurity trends that are going to be hitting you all next year. So Mary, please go on to the next slide. So in the past couple of years, a number of states across the country have passed new privacy laws. So first, there is California, which originally passed the California Consumer Privacy Act and then recently amended the California Privacy Rights Act. Utah passed the Consumer Privacy Act. Colorado passed the Colorado Privacy Act. Virginia passed the Virginia Consumer Data Protection Act, and Connecticut got in on the fun and passed the Connecticut Data Privacy Act. All 5 of these laws are going into effect in 2023. So you all may have compliance obligations with them, even if you do not have physical presences in those states. If your companies are not located in those states, if you are doing business in those states, these laws may apply to you. And just at a very high level, privacy laws, for those of you who don't have any experience dealing with them before, essentially control and limit what companies can do with information that relates to individuals. It can be contact information, medical information, financial information, education information, anything that relates to people who live in these states. These laws now control what companies can do with that data. The laws create privacy rights for these people that they can try to exercise and ask you to do things with their data, such as correct their data or delete it. And it puts obligations on you over what you're allowed to collect, who you're allowed to disclose it to, and other protective obligations that are intended to protect the privacy of these individuals. Mary, you can go on to the next slide. So when you are going through your 2023 checklist, the first thing to do is to figure out which, if any, of these 5 laws applies to your company. You have to figure out if you're doing business in these states and if you're collecting a certain amount of data relating to people in those states. There's some other threshold requirements that apply, but you'll want to go and look at the requirements to see if they apply to you. If these laws apply to your company, you'll have some work to do to get into compliance. First and foremost, you'll want to take a look at your privacy policies. Most of you will likely have privacy policies posted on your websites, but they may be in other places if you're dealing with people in other ways. They're coming into your business, for instance, or they're calling you. You'll want to make sure that they accurately and completely describe what you are doing with personal data and that you are meeting all of the requirements that these state laws place on you. Some of them require you to disclose certain things about what you're doing with that data, who you're sharing it with, why you're collecting it, how long you're keeping it, and how to exercise those rights that I mentioned earlier. You may also have the obligation to ask for consent from people before using certain types of data under these laws, particularly when it comes to data relating to children or sensitive data, such as data that relates to race or ethnicity, sexual orientation, religious beliefs, things like that. If you are disclosing data that is protected by these laws to third parties, you may have certain obligations under these laws to put provisions in your contracts with those parties that limit what those parties can do with the data. And so you want to take a look at your contracts with the third parties to whom you are disclosing data, including your vendors that get access to your data, and make sure that your contracts have those provisions in place. Next, you want to make sure that you can respond to those requests from individuals when they want to exercise their rights. Just because someone makes a request doesn't automatically mean you must delete their data, for instance. There's lots of exceptions to these rights, but you need to know how to vet them to make sure that these people are who they say they are, they verify themselves, and then you decide whether or not you can comply with their request or whether there's an exception to it. Some of these laws require you to carry out privacy impact assessments. That essentially means that when you're doing something new with particular kinds of data, new goods, new services, a new set of individuals that you're collecting data from, you may be required to assess whether or not what you're doing is going to have an impact on their privacy. And if so, whether or not you need to mitigate that impact in some way. And finally, many of these laws require, in a very general and vague way, you to have appropriate security in place. So you'll want to think through, do you have the right administrative, meaning written, technical and physical measures, such as video cameras and locks on your doors and cabinets to protect the data? You'll also want to think about doing a security risk assessment to think about what are the risks to this data, how might it get exposed, or stolen or lost or destroyed by accident? And how do we mitigate those risks? Those are some of the things that you'll want to do to get in compliance with these new privacy laws. I urge you all to take a look at them soon because, as I said, these all come online next year. Some of them on January 1, some of them in the middle of the year, and some of them at the end of the year. For those of you who are getting CLE for this, I just want to give out our CLE code number 1. It's written on the slide there. The code is 52311. Mary, you can go on to the next slide. In addition to these new state privacy laws that are sweeping the nation, we have another trend going on, which is a rash of lawsuits being filed against companies over their websites and what the websites are collecting from website users. So I think all of you hopefully have heard of the things called cookies these days, which essentially can track what you are doing on a particular website. There are other tools that your companies may be using on their websites, in addition to cookies, that collect information about the users of those websites. Plaintiffs' lawyers across the country have started filing lawsuits, class action lawsuits, claiming that some of these tools are unauthorized, illegal wiretaps, that they are intercepting communications between the users of the websites and the websites without their consent, and that they are violating state wiretap acts. In particular, they are focused currently on a particular kind of tool called session replay software, which is essentially a tool that allows a company to replay a particular user's session on their website. You can actually, through this software, see where the mouse moved as it moved across the screen of the website and see what the person typed in to the text boxes on their website if they're submitting information to a comment or if they're entering their username. These tools are used by and promoted as a way to refine websites and improve user experiences because you can see how a user gets hung up at different places in your website. But the plaintiffs' lawyers are claiming that they are illegally intercepting this communication without getting consent, particularly since there's a third party. The session replay software provider is a third party that's secretly intercepting these communications. So if your company is using any of these tools that I've identified here, you want to think about how to best position yourself to defend against a possible lawsuit. Like I said, there's many of these lawsuits being filed across the country. They are class action lawsuits. The Wiretap Act laws that are in every state, many of them have statutory damages. So for every violation, every user of the website, the plaintiffs' lawyers are saying that's $1,000 or $5,000 a pop, which can seriously add up very quickly. So if you go on to the next slide, Mary, this is the way you want to get your company best prepared to defend against this. You want to, first of all, figure out, are you using any of these tools? And if you are, you want to make sure that the privacy policy that's on your website adequately discloses that you are using these tools, particularly session replay software. Disclose what you are collecting from website users and how it's being used. Why are you collecting it? And critically, who are you sharing that information with, including the third-party software providers? And why are you sharing that information with them? You'll also want to take a look at the terms of use that are on the documents that are on your website and think about whether or not you want to have anyone who sues you for violation of anything relating to the website be forced to arbitrate their claims on an individual basis rather than on a class-wide basis, and whether or not any claims have to be brought in a particular state or court. Also, you should give good consideration to whether or not you want to have a pop-up banner. Like we've all seen those cookie banners that pop up that ask for people to click OK. Getting affirmative consent from a user is a better defense than not. If you just have that privacy policy and that terms of use on your website, they can argue, the plaintiffs can argue that they didn't actually give you consent to do what you're doing with their data. So it's better to have a cookie banner that asks for that consent. And that's all for me. I'm happy to talk with any of you in the breakout rooms, but I'm going to turn it over to my colleague, Ruth Rawls, to talk about employment needs.
Thank you, Sandy. Thank you, everybody, for joining us today. You can go ahead and go to the next slide, Mayor. So I was asked, what are the things that keep me up at night on the employer-employee side for 2023? And some of these things have been percolating around for a bit, but these are the four, my top four. Maybe I should have picked five, but I have four things that I think we should talk about today. So all things pay, anybody that's been paying any attention, we've seen a lot of that. Drug testing in cannabis is the soup du jour. Right now, we've got that all over the place. There's been some action on restrictive covenants and mandatory training. And so I'm gonna just say this once so I don't have to say it every time. In the app, we're seeing that happen. So what I'm talking about a lot of is what states are doing to address some of these issues. So we can go to the next slide. So all things pay, right? So we've seen a lot of pay laws being passed. We're seeing a lot of laws regarding how we disclose pay, how we ask about pay. I kind of put these into three buckets. They don't necessarily fall into these buckets. Pay equity laws, pay history bans, and salary disclosure requirements. All of these type of laws, which are on the state level, are geared towards eliminating the pay gap. Next slide. So wage history, pay history, wage gap laws, what's the reason behind it, all of them? And I think it's important to kind of understand this because it helps us kind of understand what the law is actually getting at, and we're trying to figure out how to comply with it. What these laws are meant to do are to get rid of historical pay inequities because information about someone's salary or pay history will follow them throughout their career. So if you were underpaid at your first job, you're going to continually be underpaid for whatever reason, generally based on historical classes or groups of people that have been underpaid in an inequitable way. So generally what these laws prohibit are employers from inquiring about an applicant's prior wage or benefits during the pre-employment process, or even considering that information when making a hiring decision or compensation decisions. Now, some of these laws permit you to ask that later, but it really deals with pre-employment discussions and that process. Next slide. In addition to pay history bans, we're seeing this new kind of thing coming around. We've seen it in a lot of states. It's pay transparency laws. And these really pop out in the sense of disclosure requirements. And again, these type of laws are aimed at combating wage discrimination by closing the pay gap. And it's from the top to the bottom when we're posting this information. We've seen laws like this on the books already in Colorado, Maryland, Nevada, and Connecticut. They already have them. We have new laws. One just went into effect in New York at the beginning of this month. California recently passed a law, and we're seeing it in Rhode Island as well. So let's talk a little bit about what these typically mean. You can go to the next slide. These are some generalities that we've seen in them. However, they are state specific, and you're going to want to make sure that you look at your postings in those states. If you're posting or advertising for positions in any of the states that have these laws, there are some differences, but generally it requires the disclosure of the minimum and maximum salary or minimum and maximum hourly rate for the position posted. Saying a maximum salary of up to $1 million, that's not going to do it. You got to have a good faith basis to lay out what that range is going to be. They do typically apply to internal and external job postings, right? So if we have an internal job board, we need to be aware of that as well. And then in addition to any postings that we're doing outside on Monster, Indeed, what have you. There's usually a record keeping requirement that go with these, depending on where you are, how long you have to keep, and what you have to say. And again, they usually have some component of not relying on any type of salary history. So we see these kind of drafted a lot of different ways, but this is the biggest one affecting job postings and disclosure requirements. The next slide. So the other big issue that I never thought I would be talking about, but I am now, is drug testing in cannabis, right? So we've seen a proliferation of medical use cannabis across the country, even in the face of federal prohibition. The states are doing what they're doing. And we've seen adult use cannabis take off as well. So what does that mean? That means it is no longer if, it is when you will have an employee test positive for cannabis if you're drug testing them, because they're either using it for medical purposes or they're using it because it's authorized within the state for adults. So those numbers are going to go up, and it's going to happen, and it's creating a lot of issues. So there's medical and there are adult use cannabis. Different things apply to those in the employment context. We've seen a ban on pre-employment drug testing, which I'll talk about. But the last piece, limits on positive drug test results, right? And we take anything away from this little discussion is this bullet point at the end. Presence does not equal impairment. There is no acute intoxication test for cannabis, meaning I cannot test someone, it comes back positive, and I know they are impaired. So it creates an issue of determining impairment. And I won't get into all the background, but cannabis stays in your system for a long time. You don't necessarily have to be impaired to test positive. And so for how employers are dealing with that and how states are regulating that, it's kind of led to a lot of these issues. We can go to the next slide. I want to just talk briefly about medical cannabis because it is different. It is different and it brings up other issues. So what we've seen in the medical cannabis use space here is we have a lot of plaintiffs in numerous states have challenged terminations for positive cannabis tests. And those claims look one of two ways usually. One, the statute that authorized the use, the state statute, has express anti-discrimination provisions in it, which means you're violating the state statute. It prevents employers from taking adverse actions, and the cases are being filed there. The second one is you're violating the state anti-discrimination statute because we're talking about medical cannabis. It is being used as a treatment for a disability. So the person that tested positive may be entitled to a reasonable accommodation. So when we're talking about medical cannabis and drug testing, we're putting ourselves into this reasonable accommodation bucket, and we need to understand what our obligations are there. We can go to the next slide. The other big thing that we've seen a lot of action on is pre-employment cannabis drug testing. Why? Because states are gearing up for adult use. They want to start addressing this first and foremost as they're going through that process. And so what states have been doing are either banning or significantly limiting an employer's ability to do pre-employment drug testing for cannabis. New York State and New York City are great examples. They've enacted laws and ordinances that prohibit pre-employment drug testing with very limited exceptions. Nevada also has a law that limits pre-employment drug testing. They have adult use as well. And New Jersey's adult use law imposes some very significant limits on an employer's ability to take an adverse action based solely on a pre-employment cannabis drug test. So being aware of your drug testing procedures, what you're testing for, and more importantly, why we are testing for it is really, really important when we start dealing with a lot of these state laws. You can go to the next slide. The other thing that we're seeing some states take action on and have been for a while are restrictive covenants. We've seen some grumblings out of the Biden administration asking the federal government to deal with these. Again, no action on the federal side. So states have been kind of taking this into their own hands. But before we get into that, I just want to make sure we're all on the same playing field in terms of what we're talking about when we use the term restrictive covenants, right? They're very common. Employers use them all the time. They're used in employment contracts, and they're really a tool to help employers protect their investment in training their employees, protect the goodwill associated with them, prevent departing employees from taking clients or soliciting other employees on their way out the door. But what a restrictive covenant means is I usually put, there's kind of three things in that bucket: non-competes, non-solicitations, and non-disclosure provisions. And I think, you know, those three things or any combination of them would fall within my definition of a restrictive covenant when we're talking about these issues. We can go to the next slide. So what our states are doing is, you know, this has been building for a while. There's probably been some abuse on the employer side of using restrictive covenants for low-skilled or low-wage workers and preventing them from leaving, preventing them from going to other jobs. You know, there were some highly publicized cases for Jimmy John's that came out with respect to the folks that were hourly workers making the sandwiches. So there's been a lot of that, and it's created a significant pushback on the state's side. And they've said, look, we're going to limit how you can use these employers, and they really have to be relevant and important. So some states have brought them down a little bit. Some states have restricted them to when they can use them. California has been long known for not having them, but we've seen other states jump on this bandwagon. Illinois, Colorado has some teeth in it with respect to trying to enforce these. So we expect to see more of that as we go along. Next slide, please. And with all of these things, before I even, well, let me cover mandatory training, and I'm going to make one comment about all of them. So the other thing that we've seen is mandatory training, employee training requirements. So I think most employers know that based on federal and state laws and court decisions, it's clear that employers should provide anti-harassment training to their employees. And it's the right thing to do. It's good procedure. It's good corporate governance type of stuff. However, some states have taken a step further and saying, okay, no, you have to do it. And if you don't, we're going to impose some penalties on you. California, Illinois, New York State, New York City have all passed laws that deal with sexual harassment training. Usually some of that training should include anti-discrimination provisions. And some of these laws have been passed in response to the Me Too movement and a lot of the cases that we've seen arise out of there. Next slide. So what are some of the commonalities for this? And again, it's state specific. It depends on what your state says in terms of what you have to do. But things that we're typically seeing in these type of trainings is they should be in person. They should be interactive. It's not just a click through, right? There should be some question and answer, something like that. There's some level of frequency to the training, once a year, every 2 years, or it has to be at least an hour long, things like that. And important is, and I've seen it in a lot of these, is how you can report a complaint or make a complaint, and what avenues do you have to do that? Who do you go to? New York has a form that you have to use and provide your employees. And the other thing is to understand that you probably should have different training for your managers and supervisors. They can subject employers to a lot of liability based on their conduct. So it's important for them to understand that as part of their training. And I think the overarching thing for all of these things that I'm talking about in the environment we're in is they are state specific. So where our employees are located is going to govern what laws apply to them. So if we have a remote workforce in multiple states, we're going to need to be aware of what laws apply to those employees sitting in those states. So this is a bit of a patchwork, but it's important to understand what we have to comply with, where our employee population is, and what type of things that we need to do to make sure that we are complying with the various state laws that we're seeing. And I think we can go to the next slide. That is it for me. I'll see hopefully some of you in breakout rooms. I'm going to pass it over to Nikhil.
Thank you, Ruth. Good afternoon, everyone. I'll be discussing a high-level overview of simple compliance steps you can take right now before end of the year to get your corporate house in good order. So with our first slide here, so why is it important to maintain good corporate housekeeping? Well, in most cases, if not all, it's required by law. For example, annual filings and annual meetings for corporations, planning for annual meetings, planning for your upcoming slate of directors for board elections. And for public companies, there's various regulatory filings that need to be made, including 10K and 10Q reports and the advanced planning and documentation that goes into that. And then, of course, we have taxes. We all know about income taxes, but we also need to be aware of franchise taxes in the case of LLCs, sales, use, and excise taxes, and also employment withholding taxes. And I know David Shapiro will discuss some of these items in further detail during his presentation. Another important item is foreign qualification to do business in other states. So where applicable, it may be necessary to file a registration to qualify your business in other states. This, of course, depends on your nexus or your connection to those other states based on things such as business activities, the location of your employees, where you provide products or services, and so on. Now, regular corporate housekeeping also helps with the organization of the business. It helps keep records up to date. It helps other members of the business stay on the same page. And it's better for the bottom line of the company in terms of avoiding penalties, fines, etc. And it also assists with other compliance efforts of the company. It allows the company to be proactive rather than reactive, and it keeps you looking forward rather than being on the defensive. It also forces the business to focus on its pain points or other potential areas of risk. And it can strengthen trust among stakeholders, among shareholders, among members in the case of an LLC, and it promotes transparency and accountability across the organization. Okay, next slide, please. So corporate formalities and best practices. When we think about corporate formalities and best practices going forward, the basics are really right here on your screen. And many of you are very familiar with these concepts, but we'll do a quick refresher here. For corporations, it's many of the things we've already talked about. It's your annual report, your annual fee, conducting your annual meeting, conducting your elections for your board of directors, your officers. It's maintaining proper corporate minutes. And a very important one, financial statements. We haven't really touched on this yet, but very important, whether they're audited or unaudited, regularly maintaining your quarterly and your annual fiscal financial statements in good order. Stock ledger and stock certificates, also very important. A lot of times we'll see the stock ledger reflect something different than what the stock certificates show. You really want to ensure consistency between those two. And for LLCs, it's very similar. Again, annual report, franchise taxes when it comes to LLCs, where applicable. So some states require the payment of franchise taxes, some states do not. So it's knowing your jurisdiction and knowing what you have to pay. Again, financial statements, documenting transfers of units in the case of an LLC, updating your LLC agreement, which again, I think David's going to touch on this when it deals with taxes. Okay, next slide, please. Okay, so common pitfalls. So all the items we've discussed so far are all examples of common pitfalls in organizing and maintaining a business. And to quickly recap, those are a failure to file an annual report or other regulatory filings when they're due, pay franchise taxes when they're due, pay state, county, local sales or other taxes when they're due, register to do your business in a foreign jurisdiction in which your company has a nexus or a connection. You want to make sure it's a significant or substantial connection, and keep up to date on your ledger or cap table, which reflects the ownership interests of the company. You want to make sure that you approve or document any transfers of ownership interests. And this next one is a big one that we sometimes see, which is prepare and sign company resolutions authorizing certain company action. Sometimes we'll see companies say, you know, we'll put this in the bucket of, we'll take care of that later. Well, it's really important, and it's too often disregarded, that when you have company action, which requires board, shareholder, member, or other sort of company approval, you want to make sure it's properly documented via a signed company resolution or a written consent. And finally, you want to make sure that you're properly calling your meetings, your annual meetings, your board meetings, your shareholder meetings, whatever the case may be, you're properly noticing them and calling those meetings. You want to make sure you're properly conducting your elections. And then now we can move to the next slide. Okay, so solutions and takeaways. A lot of these are simple, common sense, but let's just start with something as simple as setting calendar reminders well in advance of deadlines. It can be very powerful, and it can be something that you can use across your organization. You can use it with your compliance officer, but it's something that can really help you meet these deadlines. Another one that's very important is following your bylaws or your operating agreement. Make sure that the conduct of your business and what you're doing as an organization is consistent with your bylaws and your operating agreement, as the case may be. You don't want to be acting inconsistently with those governing documents. And if you find that your business has grown, your business has changed, then you need to make sure that you're amending those governing documents. This is more of a personnel suggestion, but try to be clear and specific, especially at the end of the year like this. Try to be clear and specific in defining the roles of board members, officers, company management, key employees, because at the end of the year, you often have transition. You have new members joining, you have some members leaving. You want to make sure you get everyone on the same page. And you need to understand your obligations to pay certain taxes, which again, David will touch on, but we talked a little bit about it. Sales tax, use tax, excise tax, franchise tax, employment withholding tax. You want to understand your jurisdiction. And you want to try to know what you don't know. Understand your weaknesses as a leader, as an organization. So try to figure out, what don't I know and what do I need to educate myself and my team on? And if you're ever in doubt, of course, seek legal advice. Try to build institutional knowledge throughout your corporation or your company. You can create a central repository where all corporate information can be saved, stored, and accessed. by key employees when needed. And another thing that we don't see as often, but it can be helpful and powerful, is review your internal board committees. You'll have an audit committee, you'll have other committees. Review those committees. Are they doing what they're intended to do? Are their charters up to date? Are there any vacant seats on those committees? Get those filled, make sure those committees are serving their purpose. And then just a final bonus tip before I pass it on, consider adopting a code of business conduct or a conflicts of interest policy. I'm sure many of you have policies similar to this. Some of you may not, but these types of policies are becoming more and more common in today's day and age, where compliance is more important than ever. It helps companies set uniform expectations and standards, and it establishes bright line rules for company employees who may not understand what is compliant and what is not. And with that, I will send it over to my colleague, Andy Daly, for a discussion of employee benefits.
Thanks, Nikhil. We will get right into it then. So one of the things Nikhil mentioned is making sure that the board, if you have a corporation, has properly adopted certain things. And so one of those things is, for a corporation, did you adopt an incentive stock plan during the year? And if so, has the board approved that plan or adopted that plan? And if necessary, have the shareholders approved it? The board approval is usually done. Sometimes the shareholder approval could be missed. And if the board has approved the issuance of equity awards during the year, have those awards actually been documented and granted to your participants? And have there been awards that were promised to employees that haven't been documented, or that may have been in an employment agreement offer letter? So take a look at those employment agreements and offer letters of new employees and make sure that those promised awards have been granted, or awards that were awarded by the board in a board action, have those been documented? Another thing is setting the stock value. So for example, with stock options, you've got to set the exercise price on a stock value. So have you done that consistent with statutory requirements, consistent with the requirements of the plan for setting stock value, or any other type of equity awards? That applies equally for partnerships and LLCs as it does for corporations. And even if you haven't issued equity awards during the year, are there other reasons why you have to set an equity value for the year, even if it's just financial statement reporting? Income tax withholding. Equity compensation is subject to income tax withholding. It's compensation to employees when it's either the later of when it's received or when it vests. And so at that time, there is income tax withholding required. And since there's not cash going out to the employee at that time, have you taken the steps to plan for income tax withholding? There is one exception to the later of when it's received or vests, and that's an 83B election, where the employee elects to report and pay income tax when it's received, even if it's subject to vesting. And in those circumstances, as an employer, you need to know when those elections are made, and the employee should be getting a copy of that 83B election to you so you can properly report it. Non-qualified deferred compensation. So if you have forms of compensation where it's earned in one year and paid in the next, it's potentially non-qualified deferred compensation that's subject to certain timing rules. If you've heard of Code Section 409A, that's what I'm talking about here. And if that potentially applies, you have very strict rules about when you can change the timing of payments. And when we talk about timing of payments, we're generally referring to moving payments from one year to another. And so if you've got those types of arrangements where you're deferring compensation from one year to another, before you decide, hey, we're going to accelerate payment or defer payment for one reason or another, even if it's with the best of intentions, make sure you confirm with your advisors or with your somebody that understands these rules, whether that's an acceptable change in the timing. Another thing is FICA. income tax and FICA timing are not always the same. And so when you have deferred compensation with a for-profit employer, you're generally always going to have income tax when the compensation is actually received, but that's not always the case with FICA. With FICA, there's a special timing rule where the FICA is generally due on the later of when the services are performed or when it's fully vested. And so if you have compensation that's vested now, but you're not actually going to receive it for 2 or 3 years, there could be a 2 or 3 year difference in the timing of FICA and income tax withholding requirements. And so keeping an eye on those timing differences is also important. Next slide, please, Mary. And then employee benefits, generally, your health and welfare plans, your retirement plans. Are there changes to those plans that you've been considering? End of year is a good time to implement those changes. Certain changes need to be in place before year end to be applicable for the next year. And so if those things are things you've been considering, talk to your plan document provider and get those in the works. Are there required amendments? One of the big ones that you've probably heard about if you are responsible for your retirement plans at your company is the Secure Act and the CARES Act. Those provisions are already required in your retirement plans, and some of them are no longer even applicable that were specific to COVID-19 provisions. But those amendments were going to be required by the end of this year, but earlier this year we got some timing relief on that, and they're no longer required this year, and we have until 2025 for those amendments. But just staying on top of, are there changes to your retirement or other plans that you're considering or that need to be made by year end? If you have a safe harbor plan, make sure you get if you're a calendar year plan, make sure you get your safe harbor notices out if they're required. At least 30 days before year end, which is coming up in a few weeks. Certain safe harbor plans no longer are required to have safe harbor notices, but safe harbor match plans generally are still required to have the notice. Required minimum distributions are generally required by December 31st. The first year that these distributions are required, it's April 1st for the first one, but subsequent ones are required by December 31st. So if you have participants in retirement plans that are over age 70 and a half, keep an eye on that. And if you've been involved in M&A activity in the past year or even the past couple of years, just keeping an eye on integrating benefits. Our employees, of the acquired entity being integrated into plans effective 1/1/23 or of the subsequent year. Have you done everything you need to do so that happens seamlessly into the next year? And that is all I have for you. So I will turn it over to David.
Thanks very much, Andy. Let's go right in. I'm going to try to keep this short and sweet because I know everyone's favorite topic is taxes. So Nikhil already previewed a lot of what I'm going to talk about, but I'm going to focus particularly on an issue that's a regular issue for us, which is where maybe you should be paying taxes that you aren't already. And in this environment of remote workers, that's coming up more often because states will require you to file returns and pay taxes if you have nexus in the state. And that can be both sales tax and use tax as well as income tax. And remote workers can create nexus. So if you've got a remote workforce, you've got to be thinking about, well, I really love that employee in California, but that California employee is going to require me now to start potentially paying tax in California and filing returns in California. So just being prepared for that. There was a period where there was COVID relief. That's gone. So states that had been sort of turning the other way as people were all scattered to the four winds are no longer doing so, and we're starting to see some enforcement around that. Where your property is, that's been around forever. If you've got property located in a state, you definitely have access there and you need to watch for that. But the other big one that goes back to a Supreme Court case many of you may have heard of, Wayfair. If you haven't heard of the case, it's basically a case against the big furniture seller where they were arguing they didn't have nexus in the state of South Dakota because they didn't have any physical presence. The Supreme Court said, you know what, we're past you needing to have physical presence to pay tax. People do so much online, so much virtually, that if you have customers in a certain state above a de minimis threshold, either by number of transactions or by dollar amount, and it's a relatively low threshold, you need to start filing returns and paying taxes in those states. So as businesses expand, what you want to do every year is look at, where are we? Did we hit sales in states where we haven't been paying taxes before? And sales, in the case of a services business, you look at where's your customer in many cases. Where's your client? That may be enough. And look at your 2023 projections and see, are there places where we're looking at, we just started a business relationship, but that could be ratcheting up. And you don't just have to do this for the US, you also have to look outside the US and see if there are foreign jurisdictions where you've got customers. Because especially with digital businesses, foreign jurisdictions are getting a lot more aggressive. They're sick of US companies, as they see it, taking away all their profits without paying any taxes. So pay attention to all of those. By the way, one thing I want to note on the international front that's not in the slide, but has been an issue we've been running into recently. If you have foreign payers, if you're receiving payments from a foreign jurisdiction, like if you are licensing technology and getting royalty payments, for example, you may need to be able to certify that your business is tax resident in the US, and the IRS provides a letter to do that. And if you need to provide that letter, start getting ready to apply for it now, because we're talking these days a minimum of a 6-month backlog. And if you have to wait 6 months before you can certify your residence, you may have some foreign withholding taxes to pay that you didn't expect. So let's go to the next slide, please. Okay, the other thing I wanted to just mention is Nikhil talked about keep the legal housekeeping, and that goes double for tax, because a lot of the times the way tax law works is going to be driven, especially for pass-through entities, by what the document says in terms of how you have to allocate income and who's entitled to get what deductions. So people often talk about, well, we're going to grant this equity, or we're going to shift the economics this way. Make sure you get it documented. If you have plans to do that or had an agreement in principle, you have a limited window for a partnership or LLC taxed as a partnership that has to be done no later than March 15th if you're a calendar year taxpayer, March 15th of 2023, in order for it to be effective in 2022. The sooner you get that kind of stuff done, the better. And the other thing, for those of you who operate as S-Corps, I always remind people, if you, for instance, were an LLC that made an S election, you want to go back to your corporate documents and strip out all of the stuff that related to tax partnerships, because that is that's something we've seen a lot, and the IRS looks at that and say, you might not be a good S-Corp if you have that language in your agreement still. So just a few little housekeeping tips tying back to what Nikhil was talking about that you should all keep in mind for tax. And now to bring it home for us, I'm going to turn it over to Mark Simpson.
Thank you so much. In keeping with the speed dating theme, I will speed through some of this. We're getting close to time. We want to have room for the breakout sessions. So IP, intellectual property, often gets less attention or is completely overlooked when it comes to year-end or new year corporate hygiene. It kind of hangs around in the background. And so I'm going to touch on 3 areas that can easily be inserted into your year-end or New Year's routines, and that will help with keeping it in good shape. So the first, I'm going to talk about training education, I'm going to talk about audits, and I'm going to talk about maintenance. So training and education, basically what you're doing there is you want to give everyone involved in IP creation and use a refresher on why you're doing it and how you're doing it. It's a good time to do it because this is when companies announce new directions, new business strategies, new employees come on. And if IP plays a part in your business, and most businesses have at least some element of IP, this is the right time. So if you're a tech company, if you're involved in patent type things, and engineers, innovators, creatives, giving them this training at this time helps the company to harvest and monetize their IP. People are aware of it. It's in their top of mind when they're doing their job, and it reminds them to bring these things forward so that we can get protection for them. It often also stimulates their creativity at a time when the year end, you're beginning, they may not be quite getting going yet. It kind of puts them back in the phase and to start working at it again, and it can just stimulate their creativity. Don't forget the C-suite and the board people. They need to understand the differences between the various forms of intellectual property, if it's patents, if it's trademarks, if it's copyrights, trade secrets. I can't tell how many times someone tells me they want to trademark an invention or patent a brand. And it's not a big deal in terms of we can set them straight, but if they know ahead of time exactly what they're doing with this stuff, it's just more helpful to them and they're able to more easily implement it. And we tell them about what's important and why it's important to the company strategy. The other place to remember is your marketing people. Marketing is a place with some dangers because there's a lot of creative people putting out creative things very quickly. They want to get things up on the website very quickly. They have new branding initiatives that are being thrown out, and there's usually short timelines on them. And so a lot of things can happen. People can accidentally, without knowledge, they might not realize they can't clip and paste that photograph and put it up on the website because it's not theirs to do in the first place. And if they do that, we'll be getting a cease and desist letter very quickly. So you just want to get the marketing people involved to let them know what they can't do, what they should be doing. If there's a new branding initiative, we should make sure there's clearance to use the branding. We may want to protect it with trademarks, trademark protection, trademark registration. So these are just things that are part of this training and education component that is a good thing to do. And it doesn't take a lot of time. You can get outside counsel to help you with. You can have in-house people do it and just have a half-hour, 1-hour seminar, something like that, where they can be brought up to speed. Second, I'm going to talk about auditing. So you want audits. You want to make sure that the core protections for your intellectual property is in place. And what you have been developing over the year is now in the process of being protected if it's important to the business. So branding and rebranding, I just talked about it. Are there primary trademarks involved or service marks involved, and are they protected? Have we done the diligence to make sure they're clear, and have we protected them? Utility patents. So if you're a tech company, you have core innovations that your engineers are developing. We want to make sure they're protected. Have there been improvements made during the year, which typically they are? Are we patenting them? Are we making sure they should be subject to utility patents and protected in that manner? Design patents, these often get overlooked, but they can be extremely valuable. The design patent protects the look of a product, the aesthetic. So an iPhone has a particular look to it, and Apple wants to protect that very carefully. So they might protect it by a design patent so that someone doesn't knock it off in a cheap imitation that people start buying because it looks like an iPhone. So we want to talk about that with our creative people, our engineers, and making sure that's being considered. Copyrights, as I talked about, marketing people they're putting digital content out there. Is it something you want to protect? Should we be protecting it? Do you have software developers that are developing software that could be protected by copyrights? Again, this is part of the core, maybe the part of the core of the company, and we want to make sure it's not just being created and then just sitting there. We want to make sure we can protect it so it can't be used by others and maybe monetized. Licenses are the license we need to look at. Do you have trade secrets that need to be protected by the appropriate documentation, like the restrictive covenants Ruth mentioned earlier? Finally, maintenance. So maintenance is it's a cost that can be very costly. If you have patents that are registered patents or registered trademarks throughout the year, maintenance fees will come up or renewals fees will come up. And in a big corporation, you may have a long list of these things and you just pay them routinely because it's easier. If you go through these at the end of the year, the beginning of the year, and perhaps look at what's coming up in the new year in terms of renewals and maintenance, you may find that there are things in there you are no longer using that are not valuable to the company anymore, and it's not worth spending the money to pay these maintenance fees or to renew them. And so it's a good time to look at that. They can be costly, and year end is that's when we get people doing it, looking at it, and making sure they're cognizant of it. And really that's it. I mean, our current strategic business goals being protected, that kind of flows into everything I just said. You're always looking at that. And maintenance at the end of the year, that's a good thing to be looking at, to just make sure everything we're doing that's core is protected. And there we go. I did it in about 6 minutes, 5 minutes. I think we're now going to go into breakout rooms.
Thank you, Mark. So before we jump into breakout rooms, I'm going to give everyone a second code. The number is 75813. We'll have that posted again at the end of the breakout rooms, but just to repeat, 75813. And at this time, we're going to ask everyone to join breakout for about 10 minutes. When the rooms are open, click the breakout room icon that's going to appear at the bottom of your screen, and you get a list of breakout options and choose the room you'd like to join. And look forward to seeing you in a breakout room.
Mary, it's Christina. Can you hear me?
I can. How are you?
Good. How are you?
You're not going into a breakout room?
How do you go into a breakout room?
Scroll down and you'll see the rooms, the different rooms to join.
Scroll down, scroll
You see
down.
it, the breakout, there should be an icon at the bottom. If you click on that, it should be like different options to choose from.
What am I scrolling down from? I'm still being recorded so people can hear how stupid my question is.
No.